Good afternoon, everyone. So hopefully we got a bit of refreshment, your favorite poison, some coffee, some tea. We're back for the second session today. We're still in the field of sustainability and competition law. And we're going to start with a very important contribution by Martijn Snoep. He's going to speak about sustainability in corporation. And briefly, to speak about who our next presenter is. Since 1st of September 2018, he has been the chairman of the Netherlands Authority for Consumers and Markets. The Netherlands we've been discussing so much in the last sessions, actually. He obtained his law degree from Erasmus University in Rotterdam, and until his appointment at ACM, he worked at De Brouw Blackstone Westbroek for 28 years. Operating from both their Amsterdam and Brussels locations, he gave advice to businesses about the application of competition law in the Netherlands and abroad. As a managing partner, he stood at the helm of the firm between the years 2010 and 2016. So it's a great pleasure to be able to welcome Mr. Snoep today. And the floor is all yours, if you're prepared.
Thank you very much. I hope you can hear me well.
Excellent.
Yeah, very good. So I apologize in advance. I'm sitting in a hotel room on the way to travel onward. I say carefully to fly onward, because with mixed feelings, I'm about to set off for my first flight since the beginning of the COVID crisis to Florence to address a meeting of competition practitioners on the very important topic of sustainability. So that was the only justification I could find to fly out to Florence and hope, like I hope today, persuade some of the skeptics, if they are in the audience, to follow the ideas of the Dutch Competition Authority. So, but let me first start with sketching a little bit of the background of the Dutch Competition Authority, because we are a multifunctional authority. And maybe one step back, what I'll do is I think I have about a 20-minute time slot. I have about, I think, maybe 10-15 minutes, so there's also plenty of room to ask questions. And if there are burning questions, please also use the chat in between. I'm more than happy to answer them on the go. But just one step back, we are a multifunctional authority. We are a competition authority. We are also a consumer protection authority, energy regulator, telecoms regulator. We do regulation in the field of public transportation and some other exotic areas. So the ambit of the agency is quite wide. And at the time when I took over the chair of the agency, we, together with the board, we made sustainability one of our primary goals of the entire agency. So sustainability is an important point on our agenda in all areas of enforcement. So in the competition area, we did a lot of policy work. I will come back to that in a second. But also in the consumer protection field, we made some remarkable progress. First, and I want to point that out to the audience and those who are interested, we published sustainability claim guidelines that specify for businesses in a very practical, hands-on manner what is misleading sustainability, what are misleading sustainability claims, and what are legitimate, what is legitimate commercial speech that is an advertisement that is not misleading. And we started out with these guidelines, and our next step is that we also announced that we focus on 3 sectors specifically. That is the energy, the clothing, and the dairy sector. And we did a big sweep across these 3 sectors, and we expect the first results of our findings probably later this month or early next month. And that shows, and I can only say that there is still a lot of work to do in this area. And our next step, so that's the third step, first general guidelines, sectoral approach. And then the third step is that we will take serious enforcement actions against companies who are still issuing misleading claims to the general public. Because it is extremely important that consumers trust the green claims that companies make. If they don't trust it, then two things will happen. They will not buy it, and other companies will free ride on the green investment of their competitors, and that will, that will hinder further investment into greener production methods. So that's why we think also there is a connection between consumer protection and competition. What we also did is we developed theories of harm in the area of anti-competitive agreements and anti-competitive mergers based on negative effects on sustainability. So, for example, we recently investigated a merger in the veal sector, young calves, and where the theory of harm was there could be a monopsony that would lead to lower prices for farmers, and these lower prices could have as a result that the farmers would no longer invest in more sustainable calf raising and animal welfare. Ultimately, the theory was proven wrong because we did not find that the merger would result in a monopsony and lower prices. But nevertheless, it shows how we also in the merger area take anti-sustainability effects seriously. We do the same in cartel enforcement. We look at cases, and we are looking at cases at the moment where agreements or concerted practices between companies have anti-sustainability effects. Of course, they need to lessen competition, but where sustainability is a parameter of competition, also these theories of harm that based on anti-sustainability effects are very relevant. But what, of course, drew the most attention of our work, and that you discussed also earlier today, was the situation that sometimes coordination among companies is necessary to achieve sustainability goals. And that's particularly the case where the legislator does not produce clear enough norms, or is behind there is regulatory failure in a way. For whatever reason, the legislator does not fulfill its task in protecting the environment. And we see that, and there are a whole host of reasons, and it's easy to say, well, the regulator should do it, but I think there's also responsibility on businesses to, if the legislator fails, to do it themselves. And companies can do this individually, should do this individually, but when there are clear first mover disadvantages, coordination is necessary, because otherwise the companies will go out of business. And that will not have tremendous negative economic effects, but it will also not achieve the sustainability goals that we would like to see. So that's why we came up with our guidelines. We first published a draft, invited all sorts of parties to come up with their comments, and incorporated those comments in a revised second draft, and that is now where we stand. And the reason why we published this draft and published these guidelines is threefold. First, we believe that there is a myth that competition law stands in the way of sustainability agreements. There are a whole sorts of agreements that companies can enter into that have a pro-sustainability effect, but that do not infringe the competition laws, because simply they are not a restriction of competition. To give us an example, voluntary standard setting among companies, there are theoretical models that could lead to anti-competitive effects, because the standard may serve as a focal point for coordination, but it's quite far-fetched. So by and large, the guidelines provide a lot of examples of situations where companies can actually do good and for the environment without infringing the competition laws at all, without having any anti-competitive effect. And I think this worked. At least that's what I hope, because the feedback we received from many companies, both before we issued our first draft and afterwards, is that we can't cooperate because the competition laws stand in the way. And with our guidelines, I think we show that competition law does not stand in the way. Even if you interpret the competition laws in a very strict and orthodox way. So this was one goal. Second goal was, and by the way, this is, I can say this is pretty uncontroversial. So this part of also our guidelines is, hardly any criticism on this point. I would say this is also a pretty straightforward application of competition law, but then specified for sustainability cooperation. The second goal of our guidelines was to remove the fear that we would find any legitimate attempts by companies to cooperate to achieve sustainability goals. As the companies were telling us, but there is a gray area, and we don't know. That's why we refrain from. We're on the safe side. We want to avoid getting fined, and then you also have private damages, and so that's why. And by the way, you competition authorities around Europe are no longer willing to give guidance, so that's why we are not doing it. And I said, well, in our guidelines, we published the open door policy. Come to see us. We're more than happy to spend the resources on giving specific guidance to companies. We also believe, by the way, that there are excellent practitioners in Europe that can provide that guidance. But if for some reason those practitioners find it difficult to give guidance, then please stop by, and we'll be happy to give you individual guidance. This used to be normal practice of all competition authorities around the world, but for for kind of manpower reasons, they decided to close the door a little bit, or to close the door entirely, maybe shut the door, lock it, and that was understandable. And I've been a practitioner, as you said, for 28 years, so I know these days of endless forms and exemption forms and comfort letters in Brussels and long discussions with the agencies, and that is that doesn't help anyone. But I think we went too far, and where there are clear societal benefits, it really helps to spend the taxpayers' money in giving individual guidance to legitimate questions of companies. So that's why we said in the guidelines, please come to us. And we added to that, don't worry, if you have a bona fide good faith, if you entered into a bona fide good faith agreement and you're transparent about it, you published it, you discuss it with us or you didn't, but as long as it's transparent and open and bona fide, we will not fine you. At worst, we will tell you that it is anti-competitive and an infringement of the competition law, and we ask you to change the agreement, but we will not fine you. And also that was one of the attempts to take away a little bit of the fear and the anxiety that companies were saying that they were having, and that was and that hindered them in entering into cooperation agreements with sustainability goals. And the third goal of our guidelines, and I think also because, and the reason why we did not publish a final draft of the guidelines has to do with the third goal, because the first goal, removing the myth, second goal, removing the fear, that's all pretty controversial. We can do that. I think that's anyone in Europe is more than happy with that. But the reason why we haven't finalized our draft has to do with a third goal, and that was that we wanted to spark a debate on the interpretation of Article 1013, and that's also been discussed. because we believe that the Commission's interpretation in the current horizontal guidelines is in general the right approach, but for sustainability agreements, not the right approach. And in particular, sustainability agreements that we've called in our guidelines environmental damage agreements. And those agreements are agreements, anti-competitive agreements between companies that aim to reduce negative externalities for society as a result of the production or distribution of certain products or services. So we don't think that the Commission was wrong in the horizontal guidelines, but I think now the practice and the thinking has developed that there is a subset of agreements where there are different circumstances. And these different circumstances lead to a different view on what a fair share is, as in the second condition of Article 1013. Because we believe that if you have these anti-competitive agreements between companies that have negative effects, let's say, on prices for consumers, that those agreements should be exempted on the basis of 1013 if the benefits to society as a whole outweigh the cost for the disadvantaged consumers. So the consumers, the disadvantaged consumers, will get a share of the benefits because, they are in-market consumers, but they're also, part of society. So they benefit just as the rest of society as a result of the environmental benefits. But of course, they pay a higher price in this simplified model. And that should be enough to fulfill the fair share criterion under 1013. We knew this was a controversial debate, and that would not be that immediately everyone would say, "Oh yeah, we fully agree with that." We hadn't seen it ourselves yet, but we also received a lot of support. So it's not only negative, but we received a lot of support from academics, from lawyers, from NGOs, but in all fairness, also people who questioned our approach. And this is, I think, where we are now. And we are at a very important point because the Commission now has to make up its mind and hopefully, regardless how the Commission makes up its mind, we are able also to bring a case before the courts, because ultimately it's the courts that interpret the laws and not the Commission. But nevertheless, the Commission, of course, has an important role here. Maybe to set a few things straight. So we're looking at environmental damage agreements with positive effects on the reduction of negative externalities. So what are we thinking about? Obviously reduction of CO2 emissions. That's a clear negative externality. But also nitrogen emissions are an important issue, particularly in the Netherlands. But we also see the harm to biodiversity as a negative externality, and a negative and a reduction of the harm to biodiversity is a benefit that should be incorporated and can be incorporated under 101. It can be assessed under 1013. And here is, I think it's important that the discussion, I think, whether 1013 allows for economic or non-economic benefits or efficiencies is basically I wouldn't say it's false, it's maybe too big of a word, but it's clear that 1013 speaks about benefits. And then second, what are economic benefits? Is a reduction of CO2 emission, is that an economic benefit or a non-economic benefit? And more importantly, does it really matter? I think ultimately what we believe that the founding fathers of the treaty meant with benefits is, what the word actually means, benefits. Are there any benefits? Of course, and here it comes to I think the real point is, how can we measure those benefits? How can we, can we prove the benefits? And I think the easiest way, obviously, is to be able to quantify the benefits. So that's in a way proof, but it's not really necessary. But I think by trying and forcing ourselves to quantify the benefits, it really helps us to keep a straight line, and also prevents competition authorities and courts to kind of fall in the trap of fairy tales that companies sometimes tell us, not in all areas, and maybe not even deliberately, but maybe they believe it in themselves. We know that in mergers, we know from many mergers the great efficiencies that companies put forward and the benefits, and ultimately they do not occur. And of course there are companies that will lie about this, but also from my experience, many companies are just too optimistic about the efficiencies they can achieve, and that's the same here. So that's why I think quantification of the benefits and making it as objectable as possible would do good. It's important, just very briefly, that the two other conditions of 1013 obviously remain in place, the indispensability condition and no elimination of all competition condition. And particularly the indispensability obligation is something that we take very seriously, and where we expect companies also to provide good evidence that indeed their cooperation is indispensable. So this is, in short, the goals of our guidelines, kind of the general outline of our guidelines. And I know it's a lot of information, but what has already been discussed a little bit. And please visit our website, because we provided an English translation of the guidelines so that everyone can look at it. Maybe a final point: what happened since the guidelines? Because in all honesty, we expected, because there was such a loud voice from the business community that they needed guidance, that we were somehow surprised that we only received 4 questions from companies, 4 cases where companies or trade associations approached us. We are considering this type of coordination. What do you think? So our open door policy, we had a group of ACM colleagues ready, a task force ready to answer all these questions. But in the past 2 years, we only received 4 questions, 4 initiatives. 2 initiatives, died out, not because of us, but because the companies could not come to an agreement. In one case, they couldn't come to an agreement for commercial reasons. Another case, the government decided to subsidize the initiative, so there was no longer necessary to come up with an agreement. The number 3 agreement will probably fall outside 1011, so there's just no anti-competitive effect at all. And the 4th agreement may fall within 1011, and therefore may require some guidance on the application of paragraph 3. In all honesty, I'd expected much more. I already said that. If you're listening to the business community, so I was a bit disappointed. And there can be a host of reasons why the business community did not come forward. First of all, we had, of course, the COVID crisis, and maybe they had, their priorities elsewhere. Maybe they were thinking also, not totally on logic, well, let's wait what the Commission is going to do. Or thirdly, could also happen is that the competition laws were a convenient excuse for not entering into an agreement. And now, that we remove that excuse, they point at the legislator and they will say, well, we have to wait for the legislator to come up. It's also possible. Don't know. Can also be a mixed. But clearly enough, the companies at the moment do not apparently feel enough pressure that from their customers, from their investors, from the government to come up with the agreement, or it's also possible they believe, well, we can do it alone. And I'm sure that there are companies who do that and who do follow a green strategy where they use sustainability as a competitive parameter in competition with other, and that is good, because ultimately, of course, if that is the solution, that's maybe even better. But this is where we are. I think at an important point. Hopefully, the Commission will follow our approach. And for two reasons, first of all, hopefully that will trigger more companies to come up with sustainability agreements. And second, it will more convincingly remove the myth that competition law stands in the way of sustainability agreements.
Thank you so much for this presentation. This was really enjoyable. I think your presentation reflected quite some comments that have been made already before as to how we do have the tools and how we can use them and how the door is actually open, not closed, and the sustainability agreements are not looked down upon. Yet again, we don't seem to have a really big surge in them, and we don't seem to be using all of those paths for agreements that are for sustainability, joining forces specifically as regards circular economy. Why do I always say circular? Because cooperation is the key there. If there's no cooperation, there's no circular economy, that is clear. And the bigger the company, the better in that sense, to kind of close the loop. Just to explain myself, because I've been talking about circular economy the whole day. Now I would like to open the floor actually for questions of the participants first, before I start commenting again. So please, if you have a question or a comment, put it in the chat or raise your hand. You are very welcome to join us. Do we have anyone? Then I will be the guest. One question that I always wanted to kind of ask, because I was always following, not just in terms of competition law and sustainability, but in general, the Netherlands forward-looking view on things of sustainability. So already 10 years ago when I was living in Netherlands, the little approaches and the little rules that were for making our everyday life more sustainable surprised me. It was very always forward-looking. The policies always follow. So if you take a look at academic articles, we are usually, and I say we, because me too, citing the Netherlands as the leading authority in this transition, actually. What was the most challenging aspect in starting to deal with sustainability in competition law? What was the first thing that was kind of worrisome for you as to how the companies are going to use it? Was it due to the fact that they don't know how to use the legal framework as it is? Or was the worry or concern that they're going to use it for anti-competitive purposes with the claim that they're trying to do something sustainable? Were you dealing with those two opposite aspects or not when you started thinking about guidelines? Because creating guidelines is not an easy task.
Yeah, no, I think we were thinking about both elements. So one reason was indeed that companies were quite often saying that, we really want to cooperate, but we can't. And I also remember being a private practitioner, telling the companies, yeah, but you can. So it's difficult, but you can. I mean, you cannot do everything. That's clear, and maybe you cannot go as far as you want to go, but there's really a lot you can do without a problem. But somehow there was this fear of competition authorities, and I think also, and maybe our agency is to blame, with all good intentions. I think the chicken of tomorrow case and maybe also the energy case, led the companies to believe that we were very strict as a competition authority. But and that also had to do with communication, because looking backward, we communicated for example, the chicken of tomorrow case not well enough, because in essence it was, the benefits to society or to chicken, were minimal. There was no relation to the price increase. And second, we were not convinced by the indispensability criterion, And we were proven right, because a year ago, we did an investigation, and guess what happened? Without an agreement, there are only chicken of tomorrow in the Dutch supermarket stores. So the agreement was really not necessary. And I think, but what we said in our press release, chicken of tomorrow is anti-competitive. And I think that's, and also it short-circuited the whole discussion in the Netherlands, whether competition law is fit for the future. And I've always been a very strong believer in competition law, and I think competition law is able to adjust to different market circumstances in different times. So I believe competition law is fit for the future. It's the enforcers that need to be fit for the future, and also need to communicate in a way that takes stock of sentiments and desires in society.
That was an excellent claim. Thank you very much. That the enforcers need to be fit for the future because the law can be used. Thank you. We really needed that. I have Professor Holmes raising a hand. He wants to comment, I think, or ask a question.
Just reinforcing in a sense what Martin was saying at the end there, or your question. Where does this fear of competition law come from? Sometimes I think everybody is blaming everybody else. Even Commissioner Steyer has complained that the competition advisors are sometimes too conservative. And here we are as competition advisors saying, look, it's the competition enforcers who are too conservative. I've heard in-house lawyers saying external advice is always negative and not very helpful. As an external advisor, I was often like Martin, saying to a company, yes, you can do this. And the in-house lawyers saying, oh, no, I'm not so sure. I don't think I can advise my board that, will get fined, blah, blah, blah. So those of us who take a more I'd say realistic, more robust view, need to constantly communicate this so that we can overcome this nervousness wherever it emerges in the in this whole network, enforcers, in-house lawyers, external advisors, lawyers, economists, and so forth. But top of this list really has to be the message from the enforcers. Enforcers like Martin, who's doing an excellent job. Others need to follow. The Commission needs to follow, being saying things more positively, publicly, not just privately, to us as individuals.
Good point. Thank you very much. I very much agree, because right now it's really a game of implementation and a personal approach. So the ones who are kind of executing the law to have a different out view and overlook over the topic than it is right now. Right now, I agree that it's pretty much conservative, and not just in the field of competition law, if not in the fields of all areas of business law related to sustainability. It's very entrenched and very careful adaptation and application to the notions of sustainability. Do we have any other questions or comments? Any notions? If not, then I would thank you very much for your presentation, Martin, and you're free to go, you're free to travel.
You're welcome. Thank you.
Thank you. Have a nice day. And for us, we are going to continue now. And we're actually continuing again with private practice, which makes me very happy. So we're going to welcome two practitioners from the field of competition law that are also dealing with notions of sustainability and competition law. They are from Dentons Europe, Jean-Nicolas Maillard and Yves Botteman, and they're going to present their points of view and their work basically on sustainability and competition law, outlining a bit deeper notions, I guess, than just in academia, the general discussion. So if you're ready.
Ready and happy to make you happy.
Perfect. Thank you very much for being
here. Thank you, Lela.
For the word is all yours.
First, apologies for Yves. He's still on his commute to Germany. He expected to be able to join us from Germany. We won't be able to, I'm afraid, unless he makes the cut just on time, but I doubt it.
Okay, so I'm sorry to hear, but
I fit in his big shoes. Here we are.
Perfect.
No, thank you very much. I think, you know, if I leave it, if I start where Martin and Simon left their presentations, indeed the skepticism of the European Commission is palpable. I sense, apologies Simon for putting words into your mouth, but I sense a mild irritation on that account, and I share that irritation and that mild annoyance. The debate has been going on properly for a year now, and we see no sign of, for now, but it's perhaps due to internal battles at the European Commission as well, because we hear things about some people and some groups be more conservative than others. So we hope that Martin's trip to Florence will contribute to alleviating the concerns and addressing that skepticism. I think, you know, the starting point of the European Commission, which we've heard a number of times saying that they are already doing their part through enforcement. But enforcement is certainly part of it. But today's debate, I think, is going way beyond Dieselgate and AdBlue. It's exactly on what Martin said, which is the sort of general fear and anxiety, the nervousness that we feel. And agreed, this is a little bit of a myth. Agreed, we are, as private practitioners, struggling sometimes to get our voice heard to companies, despite trying to be reassuring. Sometimes and very often we're missing that one document, official document, that proves that what we are saying is sound and can be trusted. And we have difficulties proving to the requisite level of security that is demanded by certain companies and boards. And could I have a paper in France where I operate most of the time, which would be the equivalent of the Dutch competition authorities position paper guidance that will help my life considerably. I don't know where the skepticism is coming from, to be totally honest. I again agree with Martin on the fact that on a number of occasions, not the majority, but certain occasions, it is being used a little bit as an excuse not to do something by not all the constituents around the table of a trade association, but one or two dissenting voices are sufficient to kill an initiative or to make it much less ambitious. But most of the time, I think that's a reality. It's true that the debate between the enforcers, the competition authorities, and the companies has stopped at the time where they stopped issuing comfort letters, they stopped receiving companies and engaging in debate. I think the whole debate on sustainability, but we could say the same about the vertical block exemption debate, is that the Commission and they need to that are missing the illustration, they are missing the empirical evidence, they are missing that practice that they used to be perhaps closer to 10, 15, 20 years ago. And there's a bridge to be rebuilt there a little bit. But after all, you know, Olivier Garçon, I think, at the European Commission said something at the very beginning of the debate at the European Commission. He said that competition is only a policy, and I would add that it's not a dogma, it shouldn't be a cult either. It's a policy, so we can adapt it, we can, and the enforcers, the authorities can probably, they can't do anything they want, but certainly applying it within the constraints of the law, there is a lot that they can do. They have a lot of latitude, and I think the Dutch authority is an incredible example of an authority, you know, doing their bits to foster the debate and to provide the reassurance required by companies. I'm concerned that you received only 4 contributions. Indeed, it may be due to the fact that a lot of these initiatives will be industry-wide and go beyond the borders of the Netherlands, hence an apprehension from companies. We do not see the same message from the European Commission and perhaps don't trust it. But as private practitioners, I must say, over the last 2 years, we have received a lot. This week alone, we received 2 requests for instructions by one, the trade association, 2, the beginning of a consortium which wants to discipline the supply chain and making more sustainable. And they are hoping to rally the rest of the industry progressively, but they are only starting with an initiative by 2 players. So perhaps, you know, after these sort of general words, diving into what I've seen as a private practitioner over the last year or the last few months, I think one of the interesting debates, or one of the interesting situations I've been confronted to twice now, is the control of the supply chain. And obviously that's the flavor of the moment. That's very trendy, not only in competitional circles. Way beyond that, there is this European legislation in the pipeline for a law on corporate due diligence and accountability. So basically implementing what the French have implemented in France with their duty of vigilance. So imposing constraints on companies to discipline their supply chain, to control and monitor the supply chain appropriately. And obviously there is a very strong sustainability element to that, but it goes beyond to animal welfare, it goes to human rights, it goes to slavery, it goes to a number of other obviously very important topics. And that's the question, really. When as an industry decide to discipline the supply chain and put more sustainability into it, the question is, how far should you go if you are forced by this duty of vigilance, or how far, from a computational perspective angle, can you go to discipline your supply chain and impose these best practices? But again, as private practitioner, I would argue that there is a lot that you can do. I think we have given the green lights to both initiatives that were submitted to us, one this week and one a few months ago. But nevertheless, there was a little bit of a tweak there. And again, I don't think that's a legal fantasy. There is the risk of boycott looming there in the background that is difficult to eliminate entirely. Boycott, because when you decide to adopt a more sustainable approach to supply, perhaps some suppliers will not be able to comply, perhaps they will not want to comply, perhaps they have clients who do not want them to comply, and basically you marginalize them or exclude them altogether from the market, from part of the market, a substantial part of the market. So is that boycott? I think, looking more closely at boycott cases in France, because I'm, again, French competition lawyer initially, but in other jurisdictions as well, there is always, in all decision which sanctioned the boycott case, there was always an ulterior motive that I think would be lacking. And that's what I told my clients in these particular cases. The ulterior motive generally is you have either a competitor which is providing something new and you're trying to prevent that because that will harm your business, or there are suppliers which don't want to respect what you are trying to impose on them, or clients, distributors which don't want to fall in line either, and you discipline them through collusion. Here in this particular case, the idea is not to circumvent for your own benefits the actions of the supplier. The idea is to make sure that the supplier is abiding by minimum rules that will provide more sustainability throughout the supply chain. So my view would be, we're not in a boycott case. Unfortunately, the ulterior motive I was referring to is not part of the legal tests for boycott cases in most jurisdictions. And then when you tell your clients that, they can accept it, they can sympathize with it, but some of their members, when you're dealing with a trade association, may not be as inclined to accept it altogether at face value. And then you have that little discomfort. So to be perhaps a little bit more precise, one of the cases I referred to, the one that dates from a few months ago, was an animal welfare case. And we're trying to find a way, a more human way to some extent, or more acceptable way to source these animal products with limited, or more limited at least, harm to animals. Ultimately, the animals are killed, so they do suffer some harm, but we're trying to do that in the most acceptable manner. And there were various ways of doing it, and some of the ways are particularly cruel. Some of the ways are probably, from a society perspective, more acceptable, perhaps not perfect, but more acceptable. And so when we received the instruction, they were very early in the initiative, but they were already at the stage where they wanted to announce it, despite the fact that it was not fully designed. And the press release I received that morning, the draft press release was not, in my view, perfect, because there was a lot of paternalism into it. There was a lot of we are going to do this that way, and there is no other way, and we will prohibit any other way of doing business, which probably went beyond, I felt, beyond the acceptable, and beyond what really the initiative should be about. Because what the initiative was about, after 2 or 3 days of discussion with the clients and their constituents, was probably to create a, in French we would say, a filière de qualité, so a sort of, not a label, but a quality, a virtuous circle, and not necessarily to exclude altogether the other means of ending the life of the animals. There was a lot of religious aspects into that as well, because depending on the religion, these animals were slaughtered, depended, and could impact on the animal welfare quite heavily. So what we did is, rather than just greenlighting it altogether, we found a way with the constituents of the clients to redesign it slightly, or reposition a little bit the press release and the initiative to make it exactly that, creating a quality supply chain that those who want to participate in could participate in, but there was no reason to eliminate the other ways either, or to harm the suppliers unduly by just preventing them from doing business altogether and stigmatizing them overly. I think we achieved that, and it was the right balance, and the proof of it is that the constituents accepted it really quickly, is that rather than, challenging the whole way the slaughtering was done, it was more creating that quality, I wouldn't say label, but traceability, if you want, very strict traceability of the products from raising the animal to using the byproducts downstream. So that's one. I mean, again, if the Commission could come up with a statement that disciplining your supply chain is not boycott in such and such condition, I think that would help me at the very least. Second example, the phasing out of an unsustainable substance used in a product. Here we are bordering again, getting a little bit out of sustainability. There is a strong sustainability element, but we are bordering human health issues on the two cases I wanted to tell you about. I'm not going to be able to be more specific because the two cases are ongoing. I'm still trying to figure out how we're going to design these initiatives, which have merely started. Well, one of them actually has started a long time ago, but the first one I'm dealing with at the moment with Yves is more a voluntary initiative from an industry, and they feel that the regulation is not, exactly as Simon indicated earlier this morning, is not moving at the pace it should, and basically are failing somehow. And due to pressure of NGOs, due to pressure that these companies feel from their board, their shareholders, but also because they came to the realization that that's the sense of history. They will have to do something about that particular substance. They should do it now and address it quite courageously, front-headed now, rather than wait to be obliged to do so. Basically, you're exceeding what the law requires, which is the first element of, it's not a red flag, but it's the first element that may make your life as an advisor a little bit more complicated. But again, it's desirable that you go beyond the law because the law is not sufficient currently. So that's an argument in itself. There is this first mover disadvantage that Simon referred to this morning, which means that the parties there, the players, would be very unlikely to move alone. If they would, I think they would find it highly harmful to their business. So they need to move as a group. We don't know yet exactly according to which modalities and to which rules. They will want to have key performance indicators to make sure and measure the progress, because again, NGOs are expecting that in a particular field. So yeah, watch this space, but that's a complicated one, clearly. The other one, quite similar, was a few years ago, where a particular substance was banned by law in a specific country. And then the players had 2 years, or a window of about 2 years, to come up with a different solution and change the substance. And a national authority has a case that they started against the industry at all levels, so the whole supply chain. And the case is just starting now. And we don't know yet exactly what the theory of harm is. I've got a sense, sure, I've got probably there was some very unreasonable and some very dangerous behavior at some point, or at least a slippery slope that some associations or suppliers took. But beyond that, I've got a feeling that the starting point of the authority in this particular case, there is somewhere in the background something that, they would be wary of any industry-wide collaborations, and they would rather have companies doing things on their own. So we will see when we get the statement of objections whether I'm wrong or right, but it's going to be a very interesting case. Again, not directly on sustainability, but it's a test case. I think it could be a test case for this kind of industry-wide collaboration, at least in this country, but probably a little bit beyond. Third experience in the energy sector, seeing the incredible work done by energy companies, which are often stigmatized, but obviously representing their interest. I would argue that what they're doing, or some of them are doing, is actually quite extraordinary. Finding the balance between creating the infrastructure and the products and the infrastructure to distribute the products, and finding the right balance between investing and making it worth the investment on the one hand, and on the other hand, finding and convincing the clients to adopt that particular option, because after all, there are a lot of options out there as to how you fuel a particular transport system, for instance. That's complicated. So the sustainability came in on the vertical side. So basically, how do I contractualize with my clients? How far do I go? That's one element, but there was a more interesting element on the horizontal, because there needed to be cooperation, not to develop the products, but to cooperate in the event where, with limited infrastructure available, there would be a discontinuance in the supply of the products should a particular infrastructure fail for a limited period of time. So you've got a breakdown in the factory or in the transport equipment, and you are unable to provide the product according to your contract. So were there a way to find an emergency collaboration between some of these players, bearing in mind that for the moment it's a nascent market, not yet active, just being built at the moment, and finding how you could find the right way to collaborate. There were very limited cases on that. Some of them were quite adverse, but they were providing guidance as to what you could and couldn't do. But again, difficult to balance the system. But I think we found a way. But again, the parties are taking the risk, but they had to take a leap of faith to follow our advice. Voilà, so that's the sort of things I wanted to share with you. There were other things we've seen, some more mild commitments or more general commitments by trade association industries. But again, these don't necessarily pose a problem under 111. And perhaps the last message I would reiterate what I said at the beginning. I think what we're in need of, beyond guidance, beyond block exemptions or safe harbors, but safe harbor is a good tool as well, is a very positive language from the European Commission. They need to step up to the level of debate, and I can understand why they haven't done so for internal purposes and for the whole consultation dynamic, and they want to get it right. But it's true that at some point we're going to need to see more, and I would be extremely disappointed if they were not taking in part the direction of the Dutch authority.
Thank you so much. Honestly, those insights are what keeps us going, right? So we go back from the theoretical pinpoints to actually how to use this in practice. And when I was listening to you, a little smile came on my face. I was like, well, at least regarding supply chains, you should be better off in a few months, because we do have the due diligence coming up, which is going to impose quite some issues and challenges and obligations on companies, which are going to have to accept, which kind of broadens then the field of what competition law can also do, because it spills over. So that should be more or less fixed for you in the next 6 months.
That should help, yeah.
That should help a little bit. And then the sustainable corporate governance regarding, we'll see up until where we come, but for sure it gives you more standing in saying this kind of is an obligation, and the competition law should kind of follow the spirit, right, of the legislation. Thank you very much for the excellent presentation. I enjoyed it very much. Now I will give the floor to our participants. Do we have any comments, questions related to the presentation, related to the practice in general, anything that you would like to share? Because if not, I'm continuing with great pleasure.
Could I?
Of course. Go ahead, Professor.
To practitioners, I was always wondering whether in practice there is any way to quantify or argue quantitatively about issues like animal welfare, because you mentioned one of these cases.
It's a very good question. I never had to embark into any such assessment for my part, not on that particular case I was mentioning where we found an acceptable alternative solution. No, animal welfare would be difficult to quantify, I expect. I can't think of any immediate way of addressing that particular concern. You don't have the like of emissions that you can quantify or monetize. You don't have, but perhaps Simon, you would have and address a closely related question this morning if you want to.
I was going to say on. I mean, I don't know if Martijn is still on the line. I think he's had to go, but in the chicken of tomorrow case, as was discussed earlier, the way they quantified it was to look at the willingness to pay of consumers, and looked at how much they were willing to pay. And unfortunately, they weren't willing to pay enough to compensate for the price increase. But I think what Martin would say, if he was here, is that that is too narrow an approach when you're looking at climate change issues, because you're talking about the benefits to society, which are much, much wider. And there you have to look at the sort of techniques that we've touched upon earlier, like the cost of the value of the carbon not emitted and so forth. So there are all sorts of quantitative techniques there, but you need to adapt the quantitative techniques which you use to the circumstances. And I think they are different in the context of environmental sustainability and climate change to animal welfare, which is why I think cases like Chicken of Tomorrow are talked about too much, really, because in a climate change context, it's a very specific circumstance.
In the particular case I handled, we looked at Chicken of Tomorrow at the time, and we thought, yeah, there is probably, that's why you can't adopt a general banning approach. And the way the language of the press release was suggesting, because there were other users outside that particular industry, which may not be as prompt as require a sustainable or a more human way of dealing with the slaughter. So we were de facto going to harm a side of the industry that we had no stake into and no interest in harming and no interest in disciplining. So yeah, exactly the same point as in Chicken of Tomorrow, but close.
And indeed, what you're banning, whether or not you can ban the sourcing of unsustainable products, I think again varies. In an earlier, according to the context. So in an earlier version of the Dutch guidelines, before Martijn took over as leader, there was something about in their guidelines said, of course, if you agree to produce more sustainable products, you can't take away from consumers the right to have the unsustainable products. And I remember criticizing that at the time, and Martijn immediately said, no, well, that doesn't reflect the current views. And then their guidelines were published, and it's very clear that you could, in appropriate circumstances, ban the sourcing of unsustainable products. The examples I gave earlier was, why should you have a right to fish which has been sourced on an unsustainable basis? Why should you have the right to a product that has been produced using fossil fuels when there is a perfectly valid sustainable alternative? You don't have that right.
Yeah, that goes in the broader debate, right, on also corporate governance and what's the purpose of corporation and where are the limits, right? The social contracts versus the free market. So now we're in a whole new conference. Do we have another comment or question from the audience at this point? If not so, then we will continue. Thank you once again very much, Jean-Nicolas, for this presentation. It was extremely interesting. And we continue with Professor Sartzetakis. You're ready to take the floor?
So. Just give me 1 second to find the PowerPoint.
Not a problem.
Should be here.
We also had a question right now in the chat if the recording is going to be available. The recording, yes. The PowerPoints, we don't know. I will ask every participant individually if they want to share it. If it's so, then we'll make it public at the webpage of the conference. But I'll let every participant know in due time, okay? But the recordings will be available, and I'll notify you also through the page of the conference. Thank you. So please, Professor, go ahead. Thank you very much.
Thank you. Thank you for inviting me. Let me say from the beginning, first of all, my name is Eftichios Sartzetakis. I'm at the University of Macedonia, which is in northern part of Greece. It was a great pleasure to hear all these presentations, because they are from a completely different, not completely, but from a different point of the view of an economist. Let me say first, so what I'll be presenting was adapted as I was listening to your presentation, so I took off lots of technical economic stuff, and I'll try to get as close to your discussion as I can. Now, most of what I'll be presenting will be relying on your presentations and two reports. Actually, one report that was commissioned by ACM and the Greek authority. They asked us to write a report on sustainability and competition. So we collaborated with Tassos Xepapadeas, who is at Athens University of Economics and Business and the University of Bologna, and Roman Inders, who is in University of Frankfurt. We are all three economists. Tassos and I are environmental economists, while Roman is more an IO competition guy. But we are all economists. And then we start building up a research agenda on the issue, collaborating on sustainability and competition. And we just recently put out the first working paper. I'll be presenting some of the results, but because it is very technical, I'll only be discussing it briefly. Let me say, what is sustainability? I take that all of you know the term sustainability. I only put the definition there to make sure you understand from the beginning that I will be focusing on environmental aspects. Otherwise, the whole thing gets a bit difficult for an economist to address because of issues such as animal welfare that I mentioned, and that was the reason that I mentioned it. You can extract, I'll be discussing about the methodology because that's actually what was asked from us to deliver to the competition authorities, methodologies of evaluating environmental benefits. Now, so we are going to be focusing, or my presentation will be focusing on environmental aspects, leaving out in my point, extremely important issues like distributional issues, which I think are of extreme importance when you're talking about these extremely fast and large-scale changes to the economy, which are required if we are to address climate change, biodiversity, and other such problems. That means the required intervention will have important, if not huge, important consequences to large parts of population, let's say of lower income. So there are lots of distributional issues involved, which we are not I will not be addressing in this presentation. So I'll be focusing on issues like climate change, biodiversity, which are, there is important work already done, and we can discuss it more easily. Now, there is a question, actually, this question came to us as environmental economists a couple of years ago from the Central Bank of Greece. We participated with Tassos on a couple of reports that we wrote for the Central Bank of Greece, and we participated in a number of meetings in Europe, how the financial aspect, the financial authorities should adjust to include sustainability issues into their mandate. If you think competition authorities are not flexible, you have to sit in a room with central bank guys. But anyway, there is some important, how can I say, changes to be made, especially always my understanding, and Simon was really was correct, and Martin was correct, saying about himself that it's not only regulation, but who applies the regulation. So also in the central bank case, it all depends on the figures heading the authorities. But anyway, so the general issue is the following. We are faced with huge problems like climate change, and actually, since I'm involved with climate change issues from forever, I did my PhD on tradable emission permits in 1990. The issue for me is not, if you were to ask me what is the most important issue, is biodiversity. I think that we are on the way of somehow resolving the issue of climate change. But anyway, just to point out that there are other important issues than climate change as well, that require more challenging interventions than climate change. Now, so given the importance of these issues, it seems that environmental authorities, let's put it this way, have troubles dealing with this problem. Because someone would ask, why competition authorities care about the environment now? We always had environmental problems, marine pollution, other kind of problems. I didn't see any of any such fuss about other authorities getting into this debate. It has to do with the magnitude and the time, the limited time that we have to address these issues. And then the issue is whether and how different authorities, and in our case, competition authorities, should enter into this. It is extremely important that there are trade-offs. Because when you're trying to get environmental benefits, you might have to relax, for example, in the competition area, you have to relax competition law. And you discussed a number of cases. Let me not get into details with at least at this stage. So there are two questions in my head: whether the authorities should intervene, and the other one is how. Now, why the whether is a question to an economist. The competition authorities' mandate is to make sure that efficiency is preserved in the markets work competitively, so consumers enjoy as many goods as possible at the lowest price. Correct me if I'm wrong, but that's my take about competition law. And then the question is why they should intervene. Actually, I had my PhD supervisor did and continues doing quite a lot of work for the Competition Bureau of Competition Policy, as we call it in Canada. And when Professor Llanos got me into this thing, I started talking about with Tom. My supervisor is Tom, previous supervisor or PhD supervisor is Tom Ross, who is at UBC. He said, no way, why? I mentioned this just to make sure you understand this is or in my understanding, this is a European mostly issue, or that's what I understood from selective discussion. So you have two problems in economic. If you look at it in economic terms, we have an externality problem or an environmental problem, and you have one authority. This authority should concentrate on that. You have a market problem. The competition authority should concentrate on that. And I'm trying to explain to you why in economics, I'm not answering the question. I'm just trying to pose why this is a question. And this is extremely important to understand the reaction of the other side. Okay. So I'm listing just this, since I've been listening to what you were saying here, I've listed a number of arguments in favor of intervention. Okay, just to make sure you can respond to such arguments. First of all, there is an important issue. And this came to my mind from the discussion we had with ECB. Eventually, the central bank admitted that the liquidity intervention that did during the economic crisis favored polluting industries. Why? Because those were the ones receiving the bulk of the, or they were buying the bonds. So doing their job, they admitted that doing properly their job had a negative environmental effect. In terms of competition, I was trying to transfer this argument in terms of competition. And what I can see, don't quote me though, as an economist, perfect competition might not be good. Actually, you can quote me because in economics, we are discussing about the tragedy of the commons, which must be common to you too in the literature. So that means that if you have a common property resource, perfect competition will lead to overexploitation of this resource. So somehow you have to decrease, to give property rights, to assign limited property rights to preserve the overexploitation of the resource. So that's the theoretical aspect of this line of thought. The other line of, I can give you a number of examples. I mean, I was in teaching, I had my undergrad students trying to find how come you can buy a cotton t-shirt with $3 or $4. Because you can do that in every European country, low quality or not branded, let's put it away, but definitely made from cotton. This is impossible, cost-wise. So somehow, because cotton requires lots of water, it is cultivated in Egypt, transferred to China, and then back to Europe and all these things. How come? There must be something wrong with competitive markets. Why? So there are a number of issues on conceptual issues about whether competition is always beneficial. The other argument about for the intervention is the magnitude of the problem and the time limit, which I think is the most important issue. If the environmental authority was to impose the necessary taxes, or I'm pretty sure you've heard that the price of EU ETS, the permit price, the European permit market, the price increased so much that, for example, in my country, it's the big issue about price increases rolling up and it has become a huge political issue, etc., etc. We have the example in France where they still have problems forcing environmental taxation. In Canada, we have the elections coming up late September, and the main issue is environmental taxation. So this will become an issue. So when you have the possibility to achieve environmental benefits at lower cost through other authorities, you should go for it. That's how I see it. And there are many low-lying fruits out there that competition policy should try to reap. That's my very crude understanding. How you do that, though? I think I have another 5 minutes, hopefully.
You do around 5.
Okay, I'll try to run. How? That's where you call an economist to quantify costs and benefits. Okay, I'm not gonna go through details, but environmental economics has developed a number of methodologies. We use revealed preferences, stated preferences, dose response methods, or you can use directly prices because, for example, a ton of CO2 has a price now in Europe, and hopefully it will have after Glasgow global price, and it will be higher, hopefully, than the European, the current European. But there are methodologies to quantify particular, I'm not saying all, that's why given the example of animal welfare, there are issues that they are much harder to deal with. In applying this methodology, there are a number of issues, such as the time. You need to define if there are, I don't remember in whose presentation you were discussing, for example, benefits from reduced emission, avoiding climate damages will have to go at least 70, 80 years. So you have to apply a reasonable discount rate in economics. This is a huge discussion in environmental economics, the definition of social, which is the appropriate discount rate. The other question is whose welfare should be counted. Martin mentioned that actually before going into what he mentioned that ACM will go for the benefits to the whole society rather than to consumers. So you will compare benefits to the whole society to costs of the consumers of the particular good whose price will go up. This is not so clear whether you will require compensations. Also, in the chicken of tomorrow case, in the conjoined analysis, when they use this questionnaire method to elicit willingness to pay, you were asking about their willingness to pay, but that was with the people answering had a given set of information. Was it the full? Was it the right? What is the right set of information? Should we count about their preferences as stated or as are actually revealed in the market? Because I might state that I will be willing to pay a really high price, but if a lower price is out there available, I'll be free riding on you. So there are lots of issues with how you define preferences. Now, and a few things, just that was the general setup. as it came up from your discussion, my presentation was to start somewhere here with the paper. I'll take 2 minutes, Lela, to present, to give you some of our, just going directly to the results. This paper assumed a specific framework, and we assume that people are willing to pay higher price, they are more greener, and there are some social norms. So your utility, your satisfaction, we use the term utility in the economics, increases if you do the green stuff, because there is a societal, there is a social norm rewarding this action. And if you buy the low quality, the brown version, you get punished by, you lose satisfaction. So we use this framework because I think that there are lots of, how can I say it? There is a lot of evidence that social norms do work, especially in environmental issues. And actually, if you use the data collected by this conjoint analysis based on the Chicken of Tomorrow case, you can see that people were willing to buy the cheap version if they believe that lots of people were also buying the same. So there is this, so that's how we model the behavior of the consumers, and we try different market structures to find when firms do go into an agreement. Unfortunately, it is quite straightforward to think about it. Firms do cooperate only if they have a benefit. So if they do think that the market will be expanding, if they cooperate, they will do it. If they don't, they will not. Now, there is a case that they will cooperate to forbid technological innovation. And this collaboration should be prohibited. So not all types of collaboration, communication will be environmentally beneficial. This came up with the recent statement of objection with the German automakers regarding cleaner technologies. I don't want to take more of your time. I'll thank you here, and if you have questions, I'll be glad to try to answer them.
Thank you very much for your presentation. They have been quite some similar notions presented than before, but also diverse, which I really like. It made me think a little bit about when we're, again, back at the design of consumer welfare. We have so much to talk about, not just here, but in terms of consumer policy too. Which benefit and how long, for instance, despite the fact that we've been discussing the chicken case almost the whole day today, of course, because it's one of the kind of forward-looking and backward-looking at the same time. But the benefits of permitting or not permitting are very difficult to define, because we're talking also about the health, right? Probably the consumption of one kind of chicken compared to another has health benefits and kind of disadvantages too. Do they enter in consumer welfare? So this talk and discussion can be indefinitely broadened into saying, okay, is this really just economic benefit? It is really just a benefit of choice or of quantity of price rise.
Thinking of tomorrow, Martin gave the right answer. They did the job that they did. They collect the data. There are all these problems with collecting, quantifying. That's why I mentioned them. Whether the people revealing willingness to pay had the right set of information and they knew the full extent of all the consequences and stuff like this. But still, the fact that the proposal was to include a price increase, it was kind of suspicious.
Yes, yes.
Actually, they've done it without the price increase.
This is very, very much similar to problems in every field of business law right now, how to incorporate sustainability while shying away from this system very focused on economic benefits, while we're trying to squeeze it in a system that's not based on purely economic benefits anymore. So there's a mismatch between the old and the new system. And I guess the transition is where we're supposed to do the magic right now, all of us. That's why we also have the conference on policy coherence for sustainability, which is the biggest challenge. Let me put now the word to our audience. If we have questions, comments, remarks, I would really like to hear from you to say something about the presentation of Professor, or to discuss with him some notions that were presented in the presentation. Do we have a comment? Usually the hand comes up after a minute after I start speaking, then people start raising their hands.
Should I take advantage of this one last minute to say that there is also the finance side,
yes,
which is important, that it has to do with also competition in the sense of common ownership or overlapping ownership. There is lots of movement now with big funds directing. Think about, just to give you an example, the how they call the Climate Action 100 plus. That it's a consortium of 300 plus funds holding more than, I don't know how many trillions, and they actually, I don't know if you've heard it, made sell, increase the commitment, etc., etc. There is some discussion, just to bring it up. I've seen some literature both in law and in economics. That's why I'm bringing it up. It's not directly in competition law, but it has to do with the cross area of finance. And
well, you're actually opening my tomorrow's day right now, so thank you for that. Tomorrow we're having
you are discussing this.
Yeah, so we're discussing sustainable finance, not just taxonomy, but actually financing the transition. So it's a kind of a broader topic. We're not focusing on straight funds and the financial activity, if not so, how to finance the transition, and also the traditional banking system of where it has kind of its mishaps, that it doesn't help the circular and regenerative practices to be financed right now in the private market, and then the issues that we have with public funds. So thank you for that. That was very nice intro into tomorrow. If there are no further questions, thank you very much, Professor. We're going to continue with today's schedule. So now I would kind of like to invite Professor Vedder, who is our last participant of today, to give his 2 cents into the topic and to present his research on the matter. So Professor Vedder, the floor is all yours.
Thank you, Leila. Thank you. I will just share my screen. And I hope that this is now working.
Perfectly. Thank you very much.
Okay, that's nice. Okay, so I promise that I won't mention the chicken of tomorrow. Well, I may mention it only once, but I definitely won't be spending a lot of time with the chicken of tomorrow. Instead, what I'll do is I will walk you through what I see as in a way, the fundamental challenges that underlie the whole competition and sustainability debate. And in a way, they can be traced back to what I see as the earliest competition and environment case, or competition and sustainability case. And they're still relevant today. So the overview of my presentation, the competition and what I call sustainability conundrum, how do we get out of this incredibly difficult situation? I will look at the way sustainability is dealt with under Article 101 not so much 102 TFU, and then I'll move on to dealing with sustainability under Article 107 TFU, and that allows me to contrast the public-private divide, because obviously Article 101 is addressed at private entities, so private initiatives, and that's also where some of the skepticism comes from. Obviously, these guys are trying to do nice things to, for example, improving animal welfare for chickens, but at the same time they're passing on the costs to us, and that creates an inherent, if you want, tension or skepticism. Is this really about sustainability? Isn't it just about greenwashing a price increase? And that is the normal association with what you would call the private part of the public-private divide. Whereas on the other hand, we have state aids, and state aids are addressed to member states, and member states are trusted to do the right thing. They act only in the public interest, right? So whatever they do, it is inherently good. You'll need to come up with a pretty good story if you want to convince the European Commission that maybe this state aid isn't entirely about, well, I don't know, something nice, soft and in the public interest. And I'll address some policy options for a way forward that will involve rethinking the public-private divide. And this is, of course, a really big question. It's a question that's underlined law, economics, the way we view society for decades, centuries, maybe even millennia. And rethinking that as part of competition and sustainability is not going to happen easily, let alone by itself. So we'll need to think really hard about this. The conundrum. A story about the practicalities of being more sustainable in a competitive environment. And the story is the following. I live in a small town in the north of the Netherlands. It's called Appingedam. And we have a couple of supermarkets. And actually, ever since the municipality decided to reorganize the city center, we have 2 supermarkets that are practically each other's neighbors. A couple of other shops are in the same shopping center, and there is another supermarket that is, well, less than half a kilometer away. So we have a fairly concentrated market for the distribution of food in the center of Appingedam. And I happen to know one of the owners of the big supermarket. It's an Albert Heijn supermarket, and I'm always amazed at the fact that you can walk into a supermarket and the first thing that you see, actually it's the very first thing that you see is cigarettes, tobacco. And then I asked him, because I know him, because his children went to the same school where my children went to, etc. I said, oh, but why are you still selling these cigarettes in this very prominent manner? Why? I know that several people in your family have died of cancer. We know that smoking is a major contributor to cancer. So just from a personal perspective, help me understand, why are you still, I mean, I can understand that you sell them, but why are you marketing them as prominently like that? And Hans, it's really simple. We need the turnover. If we don't do this, people will buy their cigarettes anyway. They'll probably buy them elsewhere, and we need the turnover. It's as simple as that. Now, I can't verify whether he actually needs that turnover and what the percentage is, and whether he could do without. And well, let's not go into that. But it got me thinking about the practicalities of being sustainable, trying to, for example, not market your cigarettes, tabaccoware as prominently anymore in a competitive environment. What does that take? What does that have as an impact? And when we deconstruct that conundrum, we can see that competition is good for innovation. Competition is what got us all of these new innovations, for example, and whether they are technical innovations dealing with computers, portable equipment, etc., whether they are more societal innovations, the networked society, doesn't really matter. But these were all innovations that were largely driven by competition, by companies trying to outcompete each other. And for many people, more sustainability equals innovation. There is a really big school of thought out there that says, basically, if we want to become sustainable, all we need is innovation. We'll innovate our way out of environmental pollution, out of insufficient social protection. Okay, that may well be the case, but then how do we get that innovation? In a competitive environment, everything depends on consumer willingness to pay. My second reference to the chicken of tomorrow case. willingness to pay. If there is no willingness to pay, apparently we don't care enough. It won't happen in a free market economy. Unless, of course, the government intervenes and substitutes the consumers' lacking willingness to pay with the government's willingness to pay to subsidize. And this is where we touch upon the public-private divide for the first time. Business, however, depends on what you could call sustainability leakage. Sustainability leakage means that there is insufficient incentive for business to actually be sustainable. Yes, we hear all of these cases about greenwashing, and perhaps to a large extent they're true as well, but it simply doesn't pay off for a business to be sustainable beyond a small niche. There will be demand for people, there will be demand for organic food, there will be demand for sustainable cotton, but it will be a niche demand as long as we have largely external costs involved. Regulation, so that's when the state comes in, depends on what I call carbon leakage. This is the big debate. It's the debate that my supermarket owner put forward to me. Hans, if I'm not doing this, these consumers will just go to another outlet to buy that tobacco, and I need the turnover. So this is a state saying, oof, if we regulate our industry too hard, if we push them too much towards sustainability, they will just exit our territory, establish themselves elsewhere, and then just keep on producing, perhaps polluting even more in that third country. So carbon leakage is what informs regulation. Sustainability leakage is what informs business. And when we look at the current competition policy, it incentivizes linear business attitudes, even just to focus on consumer welfare. Consumer welfare is very hard to square with more circular types of economic thinking. Consumer welfare presupposes as a consumer, I get a certain bang for my buck that can be calculated, whereas in a circular economy, it's much more difficult to actually calculate that consumer welfare. So the current competition policy incentivizes linear business attitudes, saying, okay, we need to have as much pass-on output as possible, just adding a bit more profit along the lines of the consumption and distribution chain. And then it says sustainability, that's left to the non-business sphere. So this is a very classic public-private divide type of thinking, whereby it is for the state to make sure that we get the public type of interests, the sustainability interests defended, and the market will just do everything else. And this is what we see when we look at sustainability and Article 101. We have a market where everyone is racing to be second, and when they're not trying to race to be second, basically they try to become more sustainable, they will run into willingness to pay. And sustainability beyond the willingness to pay will require coordination. It's simply unprofitable to do so on your own. And that is where the very first case, at least as far as I'm concerned, very first case on competition law and, well, a subset of sustainability, environmental protection comes in, VOTOP. And it's a fairly obscure case, never made it into a full commission decision, only made it into a commission report. But it's essentially about the Dutch Association of Tank Storage Operators. So these are companies that operate tank storage facilities. And these tank storage facilities emitted volatile organic compounds. Basically, they were leaking. It's not less that they were leaking massively, but some of the organic compounds that were stored would evaporate and thus pollute the environment. And these companies wanted to improve their environmental track record. They wanted to update their tank storage facilities so that would be less evaporation. And when they did that, they quickly found out that their consumers, basically big oil companies that want their oil and petroleum products to be stored, did not want to pay for that. The willingness to pay for a petroleum company for increased sustainability or environmental friendliness simply did not match the costs. And that makes good sense. Think back to my sustainability leakage statement. This was a 1980s case. At that time, the environment and climate change was much less of a problem than it is today. And even if it is, Do I, as a consumer, I consider myself to be a fairly well-informed and sustainability-driven type of consumer. Do I, as a consumer, care about the way my petrol or diesel is stored somewhere and the amount of petrol or diesel fumes that evaporates from that storage? I'm not even familiar with that. It took me reading this case to understand that this is a thing that's happening, that this is a form of environmental damage that is happening. So my willingness to pay was minimal. And as an immediate result of that, the petroleum companies, so the direct consumers of these tank operating companies, willingness to pay was equally minimal. Investing in the emissions reduction equipment would cost millions. Much more than a willingness to pay simply wouldn't fly. Any company trying to make that investment on its own would immediately be outperformed by all of the others. Because why would a rational petroleum company start paying extra for the storage of their petroleum products in some super tight non-evaporating container when they can just get a cheaper deal elsewhere? It didn't happen. So these guys had to get together. And apparently, I was never involved myself, but I know one of the people who was involved said they were really close to getting a commission decision that would say, in this case, this type of coordination is compatible with Article 101 under Article 101, paragraph 3, because it improves the environmental conditions and it is strictly necessary and limited to the time for the amortization of the investments needed, and there is sufficient residual remaining competition. Yes, they were allowed to pass on, at least, and that's what I'm told. The initial decision was, yes, they would be allowed to pass on that extra environmental cost as a separate item so that there would be no competition on that, but they would still compete on their normal storage tariffs. And then all of a sudden, according to my well-informed source, that changed, and the commission said, sorry, we can't do this because it will simply be a price increase, and we can't have a price increase because a price increase means a reduction in consumer welfare. And that's where the skepticism of competition law, competition authorities towards private initiatives, well, pops up, rears its ugly head. But we know that the coordination may restrict competition. We know that since FOTOP, and we know that since, well, the CZ case, a fairly well-known European case, and this Dutch case on the Nationale Energieakkoord, so the National Energy Accord, whereby basically the European Commission and the Dutch Competition Authority said, yes, there is a restriction of competition. The restriction of competition means that in this case, consumers will have to pay more for their electricity. That's the National Energy Agreement, or consumers will be reduced in their options for energy inefficient washing machines. And there may be good reasons for certain consumers to like energy inefficient washing machines. These generally have lower purchasing costs, whereas the more advanced energy efficient washing machine will have a higher purchasing cost. But for that purchasing cost may not be affordable for any and all consumers. So the bottom line is, as soon as consumer prices increase, there is a restriction of competition. To my mind, that's a fairly simplistic way of A, understanding competition, and B, also applying competition law. To my mind, there is more to competition than just the bottom line. Do prices go up or down for consumers? There's much more to competition than that. So continuing our foray into sustainability and Article 101, the escape clauses that are available for such cooperation, even if a form of cooperation does restrict competition, like it did in CSET, like it did in a National Energy Accord, there are escape clauses. There's the Wouters exception, and that requires what I would call some public law framework to entrust the public task to private entities. So it again involves public interference, a mixing of the public and the private sphere to allow for this cooperation to escape Article 101. So a purely private form of cooperation cannot benefit from the Wouters exception. It needs some kind of public law framework. We can go into all the legal nooks and crannies, but this is what I believe it boils down to. And then there is Article 101, paragraph 3, where you could simply say, and where the Commission has said in CSET, increased sustainability roughly equals technical and economic progress. You get more advanced products. You get products with a lower environmental footprint, a lower carbon footprint. The main problems here are with the pass on, the second requirement. There should be a fair share in the resulting technical and economic progress for the consumers. Now, the second requirement, the pass-on requirement, that's where the Netherlands Authority for Consumers and Markets has made a nice, very innovative approach, whereby they say that in a certain subset of cases, and I'm sure Mr. Snoep will tell us much more about that, in a certain subset of cases, it's possible for these benefits to accrue to a greater group, a group that doesn't just comprise the consumers that are affected. Because that's where the energy accord cooperation failed the ACM test. So in the energy accord, it was quite simple. There would be a reduction in emissions because coal-fired power plants would be taken offline. And we know that coal-fired power plants cause emissions. And these emissions are just unsustainable. The problem was the pass on, the second requirement, because as a result of that cooperation, as a result of taking off energy production capacity, prices would go up. And they had calculated a bit that on average, the electricity price would go up by X cents. Would that then be offset by benefits in the form of reduced pollution? And then ACM calculated what would be the positive impact of that reduced pollution. And at the end of the day, it didn't match, it didn't balance out. The price increase was higher, put shortly, than the actual positive effect in terms of avoided pollution, which of course raises a number of questions. And the most simple fundamental question is really, is it okay to limit this to Dutch consumers whose electricity price goes up? Is it okay to say, well, Dutch consumers suffer because they will have to pay a higher electricity price, so Dutch consumers should be fully compensated? Whereas consumers in, let's say, some remote Pacific island that is about to be flooded because of all of the greenhouse gases that we're emitting and the sea level rises as a result of that, shouldn't their costs also be taken into account, and the fact that we avoid some of these costs? That is the fundamental question, and it boils down to the degree of socialization that we accept. And socialization is, again, typically something we associate with the public sphere, because governments are all about socializing. Governments are all about ensuring that we act in solidarity with each other. We don't expect the private sphere, the market, to do anything like that. Well, the ACM has now taken within a subset of sustainability agreements a new approach whereby the cost advantages don't have to be just limited to the group of consumers that is affected negatively. And that contrasts rather nicely with the Commission's still narrow approach, whereby the Commission says, no, when there are costs in market A, the advantages also have to be in market A. So the fair share in a technical and economic progress also has to be in the same market, benefiting the same consumers at least. Of course, they could be wider, but the negatively affected consumers need to at least be compensated. Sustainability in Article 107 is a slightly different story. And here the basic point of departure is that insufficient sustainability is generally a market failure. The external nature of most environmental costs, sustainability costs you could call them, are seen as a market failure. That means that the market will underprovide, and as a result of that, state aid is in principle allowed. The basic point of departure for the European Commission is that environmental aid is good, it's allowed. And it puts the state and the Commission, two public institutions, in a central position. It puts them in a central position to steer the economy into this more sustainable direction. Because, as I've noticed before, if there is insufficient willingness to pay on the part of the consumers, then basically the lacking money can be subsidized by the state. But that also allows the state to choose. It allows it to choose between the forms of sustainability it wants. Do we want wind turbines? And if so, are they going to be onshore or offshore? Or would we rather have photovoltaic? Or would we rather have biomass? Depending on how we organize our subsidy scheme, the state organizes its subsidy scheme, it can overcome certain specific forms of market failures in certain specific markets with a certain specific policy objective. So it's for the state and the Commission, who largely rubber stamps it, to approve such investments into a more sustainable direction. Now, we put our faith in the state, and I can tell you that in the part of the Netherlands where I'm living, putting your faith in the state is not entirely without risk. And I'm not even referring to the fact that we have induced earthquakes here that took about a decade for the state to even recognize. I'm also referring to the fact that this is much more of a current day problem, that we have grid congestion. The state wanted to have more photovoltaics. The state wanted to have more onshore wind. And as a result of that, in this part of the Netherlands where land prices are rather cheap, we have an incredible amount of renewable energy being produced. And the result of that is that the local grids can't cope. We actually have parts of the Netherlands where no more investments in renewable energy are allowed by the grid operators, and even companies are discouraged from coming there and connecting themselves to the grid. So there's a clear coordination problem, even though it's in the public sphere. All of this can be seen in the guidelines on state aid for environmental protection and energy. And you can, again, go through all the details, go through all the rules, but you'll see that the Commission is putting itself in the steering position. The Commission, together with the state, so the public sphere, is actually steering investments here. But what about unsustainable state aids? What about pouring a couple of billion into nuclear energy? And of course, we can have a discussion on whether nuclear energy is sustainable or unsustainable or less sustainable. But Hinkley Point C is a nice case in point, whereby the initial decision by the Commission said, yeah, this is okay, we don't mind. No problems with subsidizing this nuclear power plant. And it took a couple of iterations and to the European Court of Justice to finally say, well, actually, what you need to do is you need to at least check whether such investments, in this case, in the development of a new nuclear power plant, are in accordance with EU law. And this is something that the Commission failed to do, including EU environmental law. So unsustainable state aids are hardly filtered out. Only after a long and at times also tedious learning process does the Commission find out, well, actually, maybe we should have a stricter policy in this field of state aid law. And capacity mechanisms, Hinkley Point C is one of them, is a nice example of that. Capacity mechanisms are designed to ensure that there will always be sufficient energy generation capacity. And the member state, in this case a former member state, can choose to do so by investing in nuclear energy. A member state could also do so by choosing to invest in another form of electricity production. And that other form of electricity production may have a greater or a lower carbon footprint. And it is only now that the Commission is actively starting to steer in that carbon footprint, forcing the member states that when they subsidize such capacity or generation adequacy schemes to become more sustainable. But that's already 10 years after we've had the first capacity aid approved. So rethinking the public-private divide. I've been addressing the public-private divide a bit haphazardly in my presentation for a couple of times already now. And what we see is that competition law has this inherent skepticism with regard to private initiatives. Yep, it looks like it's good and sustainable, but they're also raising the price. Why is that? Well, perhaps because we're the polluters. That would be the obvious answer to that question. So there's, to my mind, nothing inherently wrong with passing on environmental costs, even if they are coordinated at the industry level, to consumers. What we want ultimately is to have competition on these environmental costs. We want to create an incentive to have more innovation on, for example, reducing these environmental costs by having even better and cheaper pollution filters, whatever. So especially when these private initiatives, sustainability initiatives, result in price increases, maybe the initial or reported initial decision on FOTOP would be a great way out. And in the absence of that, because that is not the way competition law functions right now, we put our trust in the state. So we subsidize to overcome external costs, the lacking willingness to pay. And when we do that, basically we put on top of the market, which is still, I think, widely accepted, a very good, maybe even best distributional mechanism. We put on top of that distributional mechanism a layer that we call the state. And on top of that, another state layer, the European Commission. And that takes, if you want, that takes that whole private sphere decision into a public sphere and infuses it with, well, considerations that aren't necessarily in the public interest. As we all know, the public interest is heavily lobbied. As we all know, there are plenty of subsidy schemes out there that are overwhelmingly geared towards suiting the industries and vested industries' interests. And as we all know, the Commission is trying hard to overcome that. The Commission does that, for example, in its new policy on capacity mechanisms. Do we really need national energy generation, national electricity generation capacity, or is it also possible to simply build an extra interconnecting cable, allowing the import of that electricity from another member state? Maybe that's an alternative. And that may well be a more environmentally friendly alternative to subsidizing primarily fossil fuel-based electricity generation capacity within the member state. And another upside of that, it also helps European market integration. So what we need to do, to my mind, is to rethink this public-private divide. Sustainable economic development, just spell it out. Sustainable economic development cannot go without the intricate involvement of the private side of this. We cannot rely simply on the state to tell us what is sustainable and what is good and what is bad, because the state will always, well, if only be a bit slow to respond, the state may be lobbied. Whereas millions of consumers informing the decisions in the private sphere are much more difficult to lobby. So policy options and a way forward. Well, when we look at economics, modern economics, mainstream economics, perhaps I should say, is still all about linear thinking and focus on consumer welfare. And as a science that informs competition policy, that is fundamentally problematic, because we will not have sustainability if we keep on focusing on consumer welfare and, as it can be best calculated, short-term consumer welfare. And then economists, I often have discussions with economists and say, yeah, but you're referring to some legalese principle of environmental integration somewhere in the Treaty on the Functioning of the European Union. That can never trump the laws of economics. I respectfully disagree with that. And we need to develop a new view on, or a view on a new public-private divide, perhaps a bit less skeptical of private initiatives, of private coordination to get us greater sustainability. And if we do that and move beyond the current divide, that is what I would call primitive thinking, whereby it's for the state to do everything that is in the public interest, and we expect the private sphere to act only in its own private monetary interests, then we may have a chance of actually having a sustainable future. This asks a lot of competition law. And I'm not sure whether we're asking too much of competition law, but I'm going to just end with the last words in my PhD thesis that I wrote on competition and environmental protection. So what is undistorted competition worth if there's nothing left to compete for? At the end of the day, this can't just be about consumer welfare. This has to be about humanity's existence. And if that's the ultimate yardstick, if that's the goal that we're aiming for, then I think we should rethink competition law and its role in establishing a public-private divide. So that's the end of my presentation.
Thank you very much, Professor Vedder. This is extremely interesting. We always come back to this notion of consumer welfare, but when I say always, I mean also in terms of competition policy and consumer protection and policy that relates to consumer protection. And brilliantly, you use the words that are really, that might be used in this context of saying, well, like human extinction is also not in the best interest of the consumer in general. So maybe the consumer welfare also entails consumers actually surviving this epoch, right? Thank you for that. I see Professor Holmes has his hands up, so I'm very eager to give him the word. Please go.
Well, thank you. Actually, before the comment I was going to make, just reflecting on your last point, I was interested that Hans said that was the last word of his PhD. I think that was the last word on my discussion of an exemption. And we have to really rethink what we value when we start talking about balancing this and balancing the other. What is the value? What is the relative value of paying 1 cent more for a good as compared to having clean air to breathe and leaving a planet for our future, for our children? But the point I was going to make was I very much welcome looking at rethinking the public-private divide and the need for coherence between these different policy tools. I think that I tried to reflect that in 2 observations I've made today. One is this debate about regulation is best, private initiatives are best. It's not an either or, we need both, and sometimes one's best, sometimes another's best. I also welcomed his reference to state aid. I touched on that as one area at the beginning where we can take into account sustainability. But the other one, which we still haven't covered, and that's because so many of us know very little about it, is public procurement that I mentioned. And I do think that having had the privilege of editing and reviewing a few articles on public procurement in the context of sustainability and climate change, our colleagues who are dealing with that area, many of them are ahead of us in terms of factoring in environmental economics. They seem to, in many ways, to be well ahead of those of us who are focused on Article 101 and 102 and so forth. We can learn from them. And I certainly think that when we're planning another conference of this sort, we should get somebody involved who really understands public procurement, because I'm not that person.
Thank you very much. I didn't want to disturb you when you were speaking about that, but the first edition of the Incorporate Sustainability Conference had a day specifically on sustainable public procurement, green and social. And we had also high-level participants who were kind of presenting their point of view. They were satisfied with some progress being made, but not entirely. So they had a very similar discussion just in the framework of public procurement to ours right now. That's why I say that this event is basically on policy coherence for sustainability, because it is supposed to be so topical and so divided. But I swear, if you go and see all the days that we made until today and tomorrow too, the debates come back to the same point of having tools, but there's no policy coherence, of having the same challenges basically, and the baseline and the aim we're trying to get. Very similar recommendation as to where to go, but very little done on that matter. So it is very strange in a way that such diverse legal fields have same notions and same issues. Specifically, if you speak about consumer welfare, from yesterday, the first day of the conference, speaking about consumer welfare and protection legislation, etc., to today's, it's like there's no coherence. There's very little coherence between the 2 notions. And in this quest for sustainability, there should be some, at least some, right? To be very, very brief on that. So it's very interesting to hear that we are really coming back to the same topics and same issues. I will make sure that all the conference participants, the presenters, as well as the attendees, have a link also to the last year's conference, just in case if you're interested of where we started from last year and what was the center of the debate. Thank you very much for your comment, Professor Holmes. Do you want to say something, maybe Professor Vedder, to that?
Only that I completely agree. I mean, there's much more practical experience in dealing with sustainability as part of public procurement. There are quite a few more cases out there. There is a guideline by the European Commission that should help. There are some cases that involve what I would call stupid sustainable public procurement. i.e. specifying a specific brand of, I think it was coffee that they wanted to have, instead of saying, well, it needs to be fair trade. So yeah, there's just much more experience in that field. But indeed, it's also not my specialization, so I can't go beyond this, but yeah.
Thank you very much then to all the participants. If there are no further questions, I'm very happy to close today's discussion and welcoming you all to tomorrow's discussion on sustainable finance. It's a bit broader than sustainable taxonomy. It's basically how to finance the sustainable transition or transition towards sustainability also from the banking sector. I wish you all a wonderful afternoon, and thank you once again to all the speakers who so generously offered their time to us today. And we'll be seeing you tomorrow. Have a nice afternoon, everyone. Thank you very much.